what they call Obamacare is in serious political trouble, and another assault may be coming up. I don't know if this is going to succeed, but Hobby Lobby is suing to say, look, this mandate shouldn't force us to pay for contraceptive-style drugs.
That's right. Christian businesses are challenging the Obamacare contraception mandate because they say it violates their religious freedom. Heather Sells has the story.
Hobby Lobby founder David Green owns the Oklahoma-based Christian arts and crafts store chain. Sharing the gospel, he says, is the driving force behind his quest for success.
There's so many decisions that we have to make that we just can't make without God, the Holy Spirit guiding us, and it has been very important for us and our family to lean on the Holy Spirit.
Green employs 13,000 full-time employees and does his best to care for them. Over the years, he's raised the minimum wage to $11 an hour and closed his stores on Sundays to allow employees time for family. But he objects to the Obamacare mandate that requires employers to subsidize birth control as a part of employee health care benefits. Green believes life begins at conception and opposes birth control that prevents the implantation of a fertilized egg in the uterus. Hobby Lobby and about 40 other companies have filed suit over the requirement. The Supreme Court will now decide whether the religious views of company owners can trump a government mandate.
This would be the first time that the Supreme Court has ever recognized that corporations are protected in their religious liberty in the same way that living, breathing human beings are.
White House spokesman Jay Carney says the health care law, quote, puts women and families in control of their health care, and notes that churches are exempt from the mandate. So far, the lower courts have been divided on the issue, giving the Supreme Court even more reason to weigh in. Heather Sells, CBN News.
Well, Jay Sekulow of the American Center for Law and Justice is here with us now. And Jay, what do you think about this one? It's a tough call for the Supremes, but we're not talking about abortion, although people think that morning after pill is a type of abortion.
Right.
But it's being presented as opposition to contraception, which is a losing game.
Yeah, and that's not really what the issue is. So the groups that are opposed to what Hobby Lobby and others are doing. By the way, Pat, we've had 7 of these cases. We've gotten injunctions in all 7, including at the Court of Appeals level. We have one that is at the Supreme Court right now on an issue, but we did get the injunction in place. The question is this: do corporations have the right to free exercise of religion? In other words, can a corporation's owners put forward through their company their faith and values? Remember, the Supreme Court held just a few years ago that the First Amendment right of freedom of speech applied to corporations. So now the question really is, does it apply, the free exercise clause apply to corporations? And while the other side's trying to say it's all about contraception, it's really not. You've got a situation where business owners like Hobby Lobby and others sincerely object to this portion of the mandate of Obamacare, which is this requirement of what they consider, as you just mentioned, like the morning after pill, abortifacient. They want those not to be part of their plan. They're not saying people can't get them. They're just saying they don't want to pay for them. So I think the court's going to be very closely divided. The key vote to look for here is Justice Kennedy. And, you know, he tends to decide these cases tending towards liberty. And I think the liberty interest of the owners of these companies trump anything else. So cautiously optimistic, but it's going to be a very, very close and, quite frankly, a very complex case.
Well, it's being pitched by the opposition as this is going to be denying women the freedom to have contraception. There's no such thing. Nobody's denying it. They just don't want to pay for it. Is that the way?
That's exactly right. I was on CNN yesterday and debate on this, and that's what was brought up. Well, what about, I said, the free exercise rights of these business owners? The counter was, what about the reproductive freedom rights of these women? They're not interfering with those. They're just simply saying, we don't think the government should compel us to pay for this. Okay. And that's really what this is about. Can the government be in a position to compel a business owner to violate their conscience? And I think at the end of the day, the answer should be no, as it has been in our 7 cases. But this is going to be closely divided. Arguments will be probably sometime in February, with a likely February, March, likely outcome the end of June. Cautiously optimistic, but a very close call.
You've been suing the IRS. The IRS did some bad things under Lois Lerner in terms of 501c4 groups. What are they trying to do now? They're trying to come, is it an end run to try to limit free speech again?
Yeah, change the rules in the middle of the game. So we've got litigation pending right now with 41 cases, not just Tea Party groups, by the way, but other conservative and Christian organizations. And the IRS is proposing a game change, a rule change in the middle of the proceedings. And these rule changes, and Pat, you're one of the main architects of this whole revitalization of political engagement by conservative and Christian organizations. They believe that the distribution of voter guides or even get out the vote campaigns are not social benefit. Which is absurd. But this is the new position the IRS is going to advocate. And it's basically a post hoc justification for their already acknowledged illegal behavior. I think the courts will see right through it if these, in fact, become the regulations. But they've got to go through a long process for the regulatory review. And believe me, we will be fine. They call them comments. Trust me, your American Center for Law and Justice is going to be filing comments. You can bet on that.
Is this being driven by the White House? I mean, it's obviously ideological, and that whole thing that was going on before, I mean, it was right out of the White House. What do you think about this one?
Yeah. Oh, absolutely. I mean, they got the Treasury Department issued these proposed regulations. You know they're in consultation with the White House, with the president and his staff, certainly with the chief of staff and the White House counsel. And these proposed regulations say a get out the vote drive is now deemed to be purely political activity, not qualifying, in their view, not qualifying for social welfare benefit. And how is it that getting people to exercise their right to vote is not a benefit to the social welfare of a community? I don't get that. And the IRS is applying these 30-day and 60-day prohibitions for distribution of voter guides. You know, they tried that in campaign finance before. Those have all been struck as unconstitutional. So this is the ongoing saga of an IRS that is incapable of self-correcting.
Jay, they've got to take over this monstrous health care law. How can they possibly do it?
You know, Pat, they can't. I mean, that's the real nexus here. That's the real connect you have to draw, and you just did it so well, is that the IRS is the enforcement vehicle for Obamacare. That means those IRS agents that have been sharing information with parties they should not be doing it, sharing it with other government agencies, are going to have your most sensitive data, your health data, and they're going to be in control and enforcing it both from an economic standpoint and all this data sharing. And I think, Pat, that should be causing the American people a lot of nervousness. With the rollout of Obamacare being such a disaster, with the healthcare.gov not operating, with no one registering to do this plan, the idea that the IRS is going to be, you know, the equivalent of the police in enforcing this should be sending chills up everyone's spine. I can't even believe that they decided to let the IRS do it. And in light of all these problems, you'd think they would have figured out another way. But hopefully Obamacare falls on itself and we don't have to deal with the IRS.
Well, how's the case you've got, the ACLJ has got against the IRS? How's that proceeding?
Pat, we've just filed a recently amended complaint adding additional parties, including the IRS White House counsel, additional counts. And in fact, these proposed guidelines actually help us in the sense that it proves that what the IRS was doing before was targeting and it was illegal. So I'm really optimistic. The government's response is not due until the middle of December. So we'll get their response in the middle of December. They've got both the Department of Justice Tax Division as well as outside counsel defending these individuals that are employed by the IRS in their official and individual capacities. So there's a lot of lawyers involved. It's one of the biggest suits we've ever handled. But, Pat, they've acknowledged the wrongdoing here. They can correct this, by the way, very quickly. They're just right now incapable of doing it. Those applications that have been pending for 3 years are still pending. And before these fake proposed guidelines were issued yesterday, remember, they were offering this deal. If you'll do 40% or less of your activity is deemed, quote, political, we'll automatically give you the exemption. It used to be 49%. So if you surrender 9% of your constitutional rights, you'll get an automatic exemption. No one's buying any of this. The IRS is doing these post hoc justifications. It's a big case, big repercussions. Right. But, you know, as you know, that my first job out of law school, that's what I did. Yeah. I was an IRS lawyer. So it's, and one of my a co-counsel on the case was actually in my same office at the IRS. So we're working the case together. His name is Julian Fortuna, lawyer in Atlanta. He's working with us. We got former U.S. attorneys involved. We've got the A team is litigating this case.
Obama wants to pack the D.C. circuit, put 3 more judges on a circuit that doesn't need any more judges. All liberals, some feminists, one's a feminist. Come down always on feminist causes. Will this case come before the D.C. Circuit with that reconstituted body, or how's it going to shape up?
No, it does. I mean, the initial is before the trial court. If it were to go against us, we would appeal it. If it goes against the government, they're going to appeal it. And yes, it's going to go before the D.C. Circuit and depend on who the panel is. And if you have, as you said, if you have an en banc review, an entire court review, you'll end up with all these new judges. Here's the problem with the 3 judges. I mean, I know one of the judges very well, who was an assistant solicitor general of the under Bush's term and under President Obama. And she's a very bright lawyer. But the fact is, that's not the question. The question is, are these judges needed? And when I testified before Senator Sessions' committee on the courts, there was a real question as to the workload of these courts that are at their all-time low in the last 10 or 15 years, that the 11th Circuit, which has fewer judges and a higher caseload, they're not behind. The judges are not behind at the D.C. Circuit. So this is nothing short of court packing. The president said he wants to remake the judiciary, and by exercising the nuclear option, he's going to do that. But Pat, what is good for the goose is good for the gander. And that means what's going to happen here is when the Republicans are back in control, which will happen one day, in the Senate and in the White House, look out on who's going to be appointed. There should be no holds barred on these judicial appointments.
The gander had better win some elections. Jay, thank you so much, and happy Thanksgiving. Appreciate everything you're doing.
Happy Thanksgiving to you too, Pat.